This article was wrote by The Intercept on August the 18th, 2023. I am going to prove to all my subscribers, as well as potential subscribers, that C.C. Moore, like any genetic genealogist, will work with law enforcement to violate people's rights and get on social media and try to act credible and try to act as though they are law-abiding citizens. For all practical purposes, they are criminals in the strictest sense. You can read this article in its entirety on your own time. I am going to the pertinent part for the purpose of this video. Despite those words of caution, Moore is one of the several high-profile genetic genealogists who exploited a loophole in a commercial database called Gene Match or GEDmatch, allowing them to search for DNA of individuals who explicitly optioned out of sharing their genetic information with the police. Stay tuned. This is about to get really good. The loophole, which a source demonstrated for The Intercept, allows genealogists working with the police to manipulate search fields within a DNA comparison tool to trick the system into showing option-out profiles. In records of communication reviewed by The Intercept, Moore and two other forensic genetic genealogists discussed the loophole and how to trigger it. In a separate communication, one of the genealogists described how the facts that her organization had made identifying using an option-out profile. Let me elaborate. These two genealogists, Moore and this other individual, demonstrated to The Intercept how to manipulate this and did hide the fact that they did this. This is very relevant to the Kohlberger case, in which will be discussed here. Now let's get on to this here. Moore did not respond to The Intercept's request for comments. Now, watch this video of C.C. Moore and remember what you just read in this article. Once again, please read this article in its entirety. Now let's get to the video.
Now, I do want to ask you about some of the cases, cold cases you've worked on, but first of all, there is something that we should make clear, which is that the database you use in forensic cases is not any one of the big commercial databases. It's not Ancestry, it's not 23andMe. Can you tell us why that is?
I'm glad you asked, because this was a big misconception that was out there. I think people are starting to understand more. We are not using the consumer DNA testing companies. We're using GEDmatch, which is not a testing company. No one is sending their DNA into GEDmatch, their raw DNA. It's not being analyzed there. They are a raw data file repository, and that's what they were created for. Was if you tested 23andMe and I tested Ancestry DNA and we wanted to see if we shared any DNA, we could both upload to GEDmatch and compare there rather than paying for a second test. And so that is really important. And it's the reason we can use GEDmatch, because they will take raw data uploads. And so you could process crime scene DNA using a genotyping process like we do for genetic genealogy and upload that to GEDmatch, even if it didn't come from a consumer DNA testing company. Now, we're not using the DNA testing companies like Ancestry DNA and 23andMe for a couple reasons. One, because for those two, the biggest databases, you have to spit in a tube and send it in. And they make sure that you have to produce a lot of saliva because they want to be sure that the person submitting that DNA has given consent for their DNA to be analyzed. So they actually require more than they would need. And so you can't get crime scene DNA. You can't, unknown people and dead people cannot produce saliva to fill up, that necessary requirement from those companies. So that's the first reason. And the second reason is because after the Golden State Killer arrest, all four of the consumer DNA testing companies came out and said it was against their terms of service for law enforcement to use their databases. So I don't want to use any databases that are not welcoming us in for this application. And also I don't want to use any databases where the participants are not consented. So at GEDmatch, it's now in the terms of service. It specifically states that law enforcement can and is using the database, and people were given the opportunity to remove their data if they weren't comfortable with that. And so
step one, isolating the suspect's DNA from the crime scene. Right, that's the first part. But step two is identifying who the mystery DNA belongs to. A few years ago, if the killer wasn't already like a criminal with his DNA sitting in the criminal system, right? Well, investigators would have a really tough time finding him, right? Like the Golden State Killer. They couldn't find that guy for decades because he was a cop. He wasn't a criminal with a bunch of DNA sitting in a criminal system somewhere. But today, companies like 23andMe and Ancestry.com, they've got all of us, like criminals and non-criminals alike. We're all spitting into a tube and mailing it off to these companies voluntarily. We're sending in our DNA. So all cops have to do these days is call up those databases and submit the killer's DNA sample. And then voila, up comes an entire family tree. And likely that killer is somewhere in that family tree. Problem is you got to figure out which member of the family tree is the killer. And for that part of the process, I want to bring in Cece Moore. She is an investigative genealogist. She's known as the DNA detective. She's helped identify more than 200 violent criminals. So Cece, this is tricky and it's fascinating, but you've got this massive family tree, maybe 30 or 50 or 100 members of a family. Where do you start? How do you weed out which members of the family are innocent and which one is the one that matches what they found at the crime scene?
Well, taking a step back, it's not quite as simple as you just laid it out, because Ancestry DNA and 23andMe, which are the largest databases by far, actually bar law enforcement from using them. And so we are limited in this work to the two smallest genetic genealogy databases, which are GEDmatch and Family Tree DNA. And so we can only compare against a total of about 2 million genetic profiles. If somebody's DNA is being used for these cases, they have consented to that.
As you can see, CC Moore is nothing but a liar and someone that will violate the people's privacy rights to help law enforcement. How can you break the law while trying to enforce the law? Now, if you notice, CC Moore clearly stated that if your DNA is being used for investigational purpose for law enforcement, you option in. But yet in the Intercept article, she clearly, along with another genealogist, showed law enforcement how to manipulate the system to bypass a security feature for those that option out to use their DNA. So as you can see, she is not credible. She's nothing but a tool for law enforcement to put on the stand and lie about how they came up with a particular suspect. This is the reason why they want to keep the raw data from the SNP from being admitted, given over to the defense in the chain of custody forms. This is because this is not how they actually caught Kohlberger. This is the only reason you would want to try to prevent this information. But one thing for certain, the chain of custody forms must go to the defense. They have a right to know if this evidence was handled properly, and they have a right to those forms. But believe me, people, Kohlberger's fate has already been decided. I want to talk about chain of custody and why it's important in a criminal case. Now, y'all do recall that Bill Thompson is trying to exclude the chain of custody forms. This is something he can't legally do. Now, let's get to it. Chain of custody refers to the documentation that establishes a record of the control, transfer, and disposition of evidence in a criminal case. Evidence in a criminal case may include DNA samples, photographs, documents, personal property, or bodily fluids that were taken from a defendant or discovered at the scene of an alleged crime. To prove someone guilty, a prosecutor must prove that the evidence presented in court is the same evidence that was recovered at the scene of an alleged crime. They must be able to show that the evidence was handled properly and was not contaminated or tampered with. If law enforcement does not properly handle evidence, The evidence can be challenged on the grounds that it was tampered with, the test results are faulty or inaccurate, or that the evidence was planted at the scene of a crime. Let me stop right there. See, Ann Taylor does not seriously argue the point that Mr. Kohlberger's DNA was planted. Because if she did, her motions would be more forceful in regards to that. But I'm saying that based on the prosecutor's, Bill Thompson, motion for a protective order with all these false grounds, nothing he put in that motion to protect can prevent the defense from legally obtaining the chain of custody forms, because this goes directly to the evidence that they claim connects him. Let's continue. Because criminal prosecutions rely on evidence gathered by police officers, it is typically prosecutors who must establish chain of custody. See, Bill Thompson in the quadruple murders dealing with the Idaho 4, he can't establish proper chain of custody. He's trying to hide the chain of custody because that evidence is in jeopardy of getting thrown out. But let me tell you some people. Ann Taylor knew this, and she has known it from the beginning. This is why it was necessary to waive the speedy preliminary hearing and to waive the speedy trial. I'm going to talk about the speedy trial later on. A defense lawyer who successfully challenged the chain of custody can ask to have evidence declared inadmissible. If the judge finds that the certain evidence is not admissible, the prosecutor might not have enough evidence to continue with the case. Let's go on. Why is chain of custody important in a criminal case? When deciding whether a defendant is guilty, judges and juries evaluate the case based on the evidence presented in court. They are not permitted to conduct their own investigations. Allowing judges or juries to base their decisions on evidence that is tainted, unreliable, and has been tampered with will undermine the integrity of the judicial system. First of all, it will violate the 14th Amendment to due process. See, the defense has every right to say, we like to know who handled this evidence. We like to know their credentials. This is one of the biggest issues here in this case, and everything else is a smokescreen. Chain of custody issues are particularly important in cases involving drugs, guns, or samples that have been tested for the presence of drugs or alcohol to prove intoxication. To prove chain of custody, the prosecutor must present documentary and testimonial evidence to establish that the item presented at trial is the same item that was in the possession or taken from the defendant. See, ladies and gentlemen, Bill Thompson know this. Ann Taylor know this. Moscow PD and the FBI know that they have to produce these documents. You just can't come to court and say, this was this. You have to prove it. The reason why they don't want to have to bring this documentation, because it's going to reveal that the DNA that they had at the scene of the crime was a fresh DNA. It wasn't no trace DNA. Mr. Kohlberger did not leave. Listen, people, if you expect, ask yourself this here. He didn't leave a trail of blood. They didn't find no blood in his car. They didn't find nothing on him. Why would he leave trace DNA on a knife sheet and nowhere else on a knife? Ladies and gentlemen, I'm telling you, the facts indicate that DNA did not exist on that knife sheet. Let's go on to it. In a typical case, a police officer will collect evidence at the crime scene and give it to a forensic technician. The technician analyzes the evidence, for example, by testing a blood sample for the presence of alcohol or other intoxicating drugs, collecting fingerprints, or verifying that a substance collected at the scene is, in fact, an illegal drug. The forensic technician must document any tests that were performed on the evidence. When he is finished testing the evidence, he turns it over to the evidence clerk, who stores the evidence until it's needed for another test or to present it at trial. What is included in an evidence log? To prove chain of custody at trial, law enforcement must be able to identify all items in the chain of custody, a particular person who is in control of a piece of evidence. See, people, they got to identify everybody that handled that evidence And they don't want to have to do this. Because, see, a lot of people that handle that evidence may not have been qualified, may have been connected to tainted evidence in the past. Now, let me see where I was at. Okay, I was at the typical, let's start back. A typical evidence log will include the date and time the evidence was collected, the name of the investigator, the location where they... See, this is everything that the defense is entitled to. What Bill Thompson is trying to do is file a protective order to prevent them from getting what the courts already say you have to get. See, when they go to talking about, well, the IgG workup is not admissible. First of all, the DNA raw data snippet is where you got the hit from, not the STR. Either way it go, the chain of command of the evidence, they are trying to hide it. Why? If it was actually if it was actually touch trace DNA found on the knife sheet and you did what you're supposed to do, why you hiding it? Like I said, your conduct indicates that you planted that DNA or you're making it up. But it was definitely not on the knife sheet. Let's go on and continue reading. I lost my place, so I'm going to start over. A typical evidence log will include the date, time, evidence, the date and time the evidence was collected, the name of the investigator, the location where the evidence was collected, the reason the evidence was collected, relevant serial numbers, a description of the evidence, and the method that was used to collect the evidence. The log should also include signatures of the people who were in possession of the evidence, the date and time the evidence was transferred, the amount in which it was which the evidence was transferred, and the security conditions while the evidence was being handled or stored. Everything that the defense is asking for as far as chain of custody, who worked it up, they're entitled to this here. See, what these prosecutors been going into the court with the DNA and saying, oh, they're not entitled to this. This is a tip. But the issue here is not a tip, the chain of custody. We want to know who handled it, who worked it up, what was their analysis. Every defense is entitled to this here. Now let's go on down. Challenging the chain of custody in a criminal case. This is what Bill Thompson and them are trying to hide, like a lot of these DNA cases, where these corrupt judges is going along with it. But a lot of times these lawyers are not making the proper arguments about the due process challenge to the evidence. A defendant can challenge the chain of custody of a piece of evidence by questioning whether the evidence presented at trial is the same evidence that was collected at the scene of the crime. If there is any discrepancy in the chain of custody and law enforcement cannot prove who had the evidence at a particular time, the chain of custody is broken and the defendant can ask to have the evidence declared inadmissible so that it cannot be used to try to convict the defendant. This is why we have this Kohlberger case being stalled. Ann Taylor is working with Bill Thompson. I'm going to pause right here, but I'm going to elaborate on why I say Ann Taylor is working with Bill Thompson. Had she went to the speedy preliminary hearing, people, remember, people, you don't need any discovery to go to a preliminary hearing. And since we know that discovery can take a while, and because even if you went to discovery, you're not entitled to a lot of discovery going to a preliminary hearing. Now, had she took the time to go to that speedy preliminary hearing, she could have asked about who collected the evidence, setting all this up for discovery later on, getting that testimony on the record. But see, Ann Taylor and Bill Thompson has already worked out a plea deal for Kohlberger, okay? This is why she nor the prosecution, want testimony on the record at this point. At a preliminary hearing, well, we're going to deal with the speedy preliminary hearing because when they waived the speedy, I already knew it wasn't going to be a preliminary hearing. Once you get that testimony on the testimony under oath, you got them. But her job was never to get police or any officer testimony or witness under oath. Let's continue. Like I said, to prove chain of custody, prosecutor must present evidence that proves the evidence is what it is. They're not going to be able to do that. They already let you know they can't do that. This is why they asked in the court for a protective order. But see, if judge grant the protective order, born chain of custody forms and hey, this case is going to get reversed, people. This case is going to get reversed. Period. So this is the biggest problem you have. Let's continue. The chain of custody can be broken if a custody form is labeled incorrectly, if a transfer of evidence takes unreasonable amount of time, or if there is reason to believe the evidence was tampered with. Excuse me. You notice throughout the probable cause affidavit, the motion for protection order, there is no dates. The dates are missing. Even if there is sufficient testimony that the evidence was what is purports to be, and testimony has been offered to prove the chain of custody, discrepancy as to chain of custody can still be challenged, and a judge or jury can use those discrepancies in assessing the weight and credibility of evidence after it has been admitted. I'm going to end that right there. I'm going to go right into something else about this case.
As number CR 29222805, this is State of Idaho versus Brian Koberger. Mr. Koberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor and Mr. Logsdon. Mr. Thompson, Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to inquire of counsel. Ms. Taylor, what's the status at this time?
Thank you, Your Honor. We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Koberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
This brings me to the waiver of Brian Koberger's speedy preliminary hearing induced by Ann Taylor. Ann Taylor had him waive his speedy preliminary hearing to obtain discovery. Now let me show you what the Idaho state law say about discovery. This brings me to Ann Taylor having Brian Koberger waive the speedy preliminary hearing in order to conduct discovery. See, a lot of people are under the impression that Ann Taylor needed discovery to prepare for the preliminary hearing. If you are of this opinion, it's because you don't understand how the law works. You are one that cannot actually go up in court and represent themselves from the trial court to the appealing court to a superior court. This is why you eat up those narratives. But guess what? I'm going to help you out today. This is an article wrote by Justin A. Biles, posted March the 2nd, 2023 by the Idaho State Bar. Let me give you some context before I begin. When Ann Taylor waived the speedy preliminary hearing, people, it was already predetermined that a preliminary hearing would not occur. I'm going to explain it to you. Let's get into this article. As you can see, discovery, the right to have all the evidence the state has. It is fundamental to the criminal justice system. It defines the universe of case and the ground on which the battle of the case will be fought at trial. In the criminal context, and especially in the misdemeanor cases, most discovery is provided by the state. The arresting officer will usually write an affidavit of probable cause in a police report. The officer will often wear a body camera and will collect physical evidence. If a laboratory test is required, the state will also provide laboratory reports. The defendant is entitled to review such evidence when the state decides to charge them with a crime. Now, I want to get to this very important, pertinent part. We're going to go to Idaho Criminal Rule 16. Like I said, this applies to misdemeanors and felonies. Discovery in criminal cases in Idaho is governed by ICR Rule 16. Among the requirements, RCR provides clear timeline to keep criminal cases moving and for the state to provide timely discovery to criminal defendants. RCR 16B permits a defendant to file a written request for discovery to the prosecutor pursuant to ICR 16F1. The party on whom a discovery request is served must provide written discovery response within 14 days. If a party does not provide discovery within 14 days, RCR 16F2 states, unless otherwise ordered by the court on a showing of good cause, excusable neglect. The failure to file and serve a response within the time required by the rule constitutes a waiver of any objection to the request and grounds for the imposition of sanctions by the court. You notice that Ann Taylor kept filing motions for discovery. She stated she's not asking for sanctions. The court never imposed sanctions. Let me tell you why, people. Because the prosecutor can play with discovery pretty much in any state, just like Idaho. But since we're talking about the state of Idaho, I'm finna show you. The prosecutor can sit up and delay discovery, and I'm gonna show you why. Because the Supreme Court in Byington put a standard up where the defendant must show how withholding discovery harmed them. But now let me show you how Ann Taylor removed Brian Kohlberger from being able to prove this burden and getting a dismissal. Now, the rule is straightforward. If a party fails to if a party fails to provide a timely response to a request for discovery and cannot show good cause or excusable neglect, the court may impose sanctions. May mean it's up to the court. They don't have to. The standard provided by the plain text of Idaho Criminal Rule 16F2 is reasonable. If a party fails to comply with a clear deadline and cannot demonstrate good cause or excusable neglect to justify its failure, then there is no reason why a court should not impose sanction. The good cause, excusable neglect standard weeds out those cases in which a delay is justified, leaving only the case in which failure to provide discovery response should be unacceptable. We all see that in the quadruple murders in Idaho. Bill Thompson refused to provide discovery. It's not justified, but there's a catch here. Now let's go over here to the prejudice standard provided by the Idaho court in Byington. It applies to both parties and creates a no harm, no foul rule that keeps one party from gaining a windfall. However, such a standard is not based on the text of ICR 16. Basically, in this article, it's showing you that the Idaho Supreme Court has a different standard from the ICR rules. So, since the Supreme Court of every state is the final authority, that is what we're dealing with right now, the Supreme Court Byington prejudice standard. Additionally, given the way that the misdemeanor, well, I'm not going to even read that part, but let me just tell you this here. Let's get down to the prejudice part, because I want to bypass a lot of things that don't have anything to do with this case. The prejudice requirement created by the Idaho Supreme Court imposes a heavy burden on the defendants to show prejudice and frees the state from any consequences for unjustified delays in providing timely discovery. Unless the defendant can show that their defense is prejudice, the state is free to delay any discovery response without good cause or excusable neglect for as long as it wants. The state can effectively shelve a case for months without any sanctions. Now, let me tell you why this is why Ann Taylor had Brian Kohlberger waive the speedy preliminary hearing and waive the speedy trial. Had Brian Kohlberger never waived the speedy trial and they kept asking for discovery, then he could have showed the prejudice. The prejudice would have been, now he's forced to go to trial with the counsel not being fully prepared. He's being forced to go to a speedy trial unprepared without all the evidence. And this would have prejudiced his defense because it would have caused ineffective assistance of counsel. This right here would have been an effective reversal on appeal. See, Ann Taylor had to remove the speedy trial so he can't scream prejudice. As you can see, people, why did Ann Taylor make the world believe that they needed to waive the speedy preliminary hearing for discovery when you're looking at it right now that discovery can be shelved and played with by the prosecutor for as long as his life? See, this is why you never waive a speedy trial. You never waive a speedy preliminary hearing for all practical purposes. And Taylor, you have been exposed. Y'all have a good evening, good morning, and welcome to Speak Van Holen.
Feel me? Shake it up. Yeah, feel me? You feel Feel me.